If there was one thing I would want anyone to know about the child support process is that having an order for your child is you helping to protect your child. Do not be afraid to come into court. The court wants to do what's best for your child and needs to listen to your side of the story, but be prepared.
When we know that a parent is a victim of family violence, we will take their case through the court process, and at court we will make sure that we negotiate with the parties separately so that no one feels any pressure to come to an agreement that they don't feel comfortable with. We'll also ask the court to make a finding of non-disclosure, and that means that the victim's address won't be on any of the court documents and will remain confidential.
In a child support case, the OAG represents the interests of the state of Texas. It is oftentimes thought by both the custodial parent and the non-custodial parent that the OAG often represents the other party. But in essence, the Attorney General's office represents the interests of the state.
If a customer speaks a language other than English as their primary language, we do have interpretation services available. That's another piece of information that you'll want to let us know up front in the process so that we can make sure to make arrangements for an interpreter to be present whether you're coming into the office or at court. There are a number of documents you might want to bring to court to demonstrate family violence. Certainly, if you have a protective order, it would be critical that you bring that to court. Also, any police reports that you might have. You might bring any threatening letters from the abuser or notes from the abuser that you feel demonstrate a threat to you.
If you have medical records that are a result of the family violence, and you can get to them, bring those as well. What is very helpful to a court is for you to have a diary or calendar of the events that have happened. If there's been threats and intimidation, write down the day and the time and the place that happened and bring it to court. The one piece of evidence that most people like to use and think that they can use and cannot, in most cases, is a letter from their friends or relatives or people that have knowledge of what's been going on, even if it's notarized. You may have heard the term hearsay, and what that means basically and very simply is that you're trying to tell the court what somebody else said, and you cannot do that unless they want to come to court and testify. So if someone knows some very important facts about your case, you need to see if they can come with you to court to testify about that case. Now, if it's something that the other parent said or did or wrote, then you're allowed to bring that. So if you have emails or text messages or the other person's Facebook page where they have made statements or comments that you think it would be important for the court to know, then it's okay to print that out and bring it.
I think the most important thing to think about when you're preparing for court is what order do you want? This is your opportunity to get an order that's safe, that's workable, that you feel is in your children's best interest. And so really thinking about the aspects of custody and the visitation ahead of time is really important. I think also knowing that it can be an all-day process, so allowing yourself that time and making any child care arrangements that you need to make is important.
It is possible in some situations to do a hearing over the telephone where the custodial parent can call into the courtroom rather than appearing physically. My advice would be to contact the court coordinator or just talk to our staff inquire about whether the possibility is there to appear by telephone rather than in person.
The judge's role in the child support process is to listen to the evidence that's presented to the court and then to put in place the laws of the state of Texas that results in an order that's in the best interest of the children that are before the court. The court can do many things to make you feel safe. They can have a bailiff stand beside you. During the negotiation process, you can be kept in a separate room from the other parent and only brought in at the time of the hearing. The court will protect you during the hearing by not allowing the other party to badger you, to give you signals that appear to be a threat or intimidation, if the court knows what's going on. And so it's very important that you do advise the Office of the Attorney General that there is this threat.
When you arrive at court, different courts have different security measures. Some courts will have a metal detector and some courts don't, and some courts have a large number of security personnel and some courts may or may not have that. So if you like, you can always go down to the courthouse ahead of time and kind of check out what the situation's going to be. But know that on the court day, the day of court, it's pretty hectic.
The hearing process can be in some ways very fast process and in some ways very slow. It will be slow in that the child support docket often has up to 100 or more cases on the docket for the same day. So you may be waiting in court for a long time before you're even talked to.
We can do our best when we're aware of family violence to keep you as separated as possible from the abuser, but just be aware that it is a crowded space and it is a hectic environment. The second thing to expect at court is that we should be negotiating with you separately. No one should be sitting down at a table. If we're aware there's family violence, we won't put you in that position. Even if we negotiate separately and we're able to come up with agreements on custody, support, visitation, and the medical support, the judge may still want to speak with the parties, and so they could be brought up in front of the judge together.
If there is going to need to be a hearing before the judge, then the process will be much faster than you think. The judge will have a limited amount of time to hear your case. You will be called before the judge. You will be sworn in to tell the truth. And then the attorney for the Attorney General's office will ask both of you questions about the issues that need to be decided by the court. During that session, it's important to try to remain calm. The court will give you a chance to tell your side of the story.
Most families in a child support case will get what we call a standard order that has joint managing conservatorship, where the rights and responsibilities for parenting are shared, and a standard possession order, which includes visitation the first, third, and fifth weekend, Thursday nights, and alternate holidays, and a summer vacation as well.
In making a determination in court about custody and visitation, the court will start with the premise that both parties can agree and do what's in the best interest of the child together. And in a family violence situation, it may be that the court would determine that the parties cannot work together, and in that case they would do a sole managing conservatorship and possibly limit the visitation or set up special rules to protect the child.
When there's family violence, the visitation can be modified in a number of ways based on the testimony that the court hears. The court can make any variety of decisions about how that should be done.
So the things that you should think about ahead of agreeing to a custody and visitation arrangement are drop off and pick up. Does that need to be at a neutral site? And whether or not you feel the visitation needs to be supervised in any way.
If you get into the courtroom and you're either in the negotiation process or fixing to start a hearing, and you feel that things are not going the way that you want, you feel that you need to get some more evidence, or that you do need those police reports, or you do need to go talk to some friends to see if they could come to court and testify for you, there's a couple of things that you could do. The first is that you can ask that the case be reset to another day. If the court does not want to reset the case, then you also can ask the court to enter a temporary order, which is just what it sounds like. And it could be on one specific issue or it could be on several issues. If the court is going to order visitation and you're just not sure that it's going to work, it may be that you can ask the court to do a final order on custody and child support and do a temporary order on visitation and come back in 3 or 6 months to see how things are going.
The most important thing to remember is that this order is going to be in place for a long time and that the Office of the Attorney General doesn't modify or enforce custody arrangements, and so make sure that it's a workable plan for you.